declined to hear oral arguments in the case of Erick Jones versus Carrols LLC. Each party will have 15 minutes in which to argue their case. The appellant may retain up to 5 minutes for rebuttal. If you're the appellant and you wish to retain that time, let me know when you come up to the clock. The podium, I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed with you.
Thank you, May it please the court. I would like to reserve 5 minutes for rebuttal.
Thank you.
3 times I've been before this court to argue this case. 3 times the issues in this case have been fully briefed. There's no new evidence, there are no new documents revealed. The only really new item of any legal significance are the Arnold decisions, which were issued by the 8th District Court of Appeals, which confirm in detail what Erick Jones has been arguing for the last 4 years, and that is that the Carrols arbitration agreement is unfair and unconscionable. It is unenforceable under Ohio law, and that there's really no way that this agreement can be upheld in terms of either unconscionability, enforceability, or the scope of the arbitration agreement. First of all, it is pretty clear that there are tort issues in this case, tort claims that are post-termination. There's no way that those post-termination claims can be within the scope of an arbitration agreement that is supposed to apply to employment-related matters.
Are you bound by your pleading? I think the other side is arguing that your complaint alleges everything happened in the scope and course of employment.
Well, I specifically pointed in my brief to the paragraphs in my complaint, which for purposes of this claim have to be taken as true, that some of these claims occurred outside the times, that is after Mr. Erick Jones was terminated. So there are allegations in the complaint that there were post-termination claims of defamation, invasion of privacy, intentional infliction of emotional distress that occurred after Mr. Jones was terminated. So to the degree, the court really didn't address, I know the court indicated, the trial court indicated that, but if you read the complaint, and I've listed specific paragraphs in my brief, it's clear that there are also post-termination claims, and obviously those claims are not employment-related. They are independent torts. Any person would have the ability to bring those claims regardless of the employment relationship. The only difference is that in this case it's just fortuitous that the tort fees will happen to be an employee. But the 8th District Court of Appeals Arnold, I think, addressed that in great detail, because, you know, torts of this type, malicious torts, are independent of any employment relationship, and therefore are not within the scope of any employment agreement. The agreement is also unconscionable, both procedurally and substantively. First of all, because of the unlimited scope of the agreement. One of the things that has to be present is a voluntary meeting of the minds between the employee and the employer. Given the broad scope of the arbitration agreement, including Burger King's argument that it applies to torts outside the time of employment, that it applies to claims outside the scope of an employee's employment. There's no way that Erick Jones would realize what he was giving up when he was presented with this agreement, did not sign it, simply returned to work in August of 2006, and they claim that he is somehow bound by this agreement. There couldn't be any meeting of the minds, because if you say that claims outside the scope of employment, it's unlimited. And here also you have the fact that the agreement itself states that it also applies to claims of Erick's family members, his wife and his children. There's no employee. And then if you look, secondly, at the ambiguity in the agreement, on the one hand, the poster and the memo indicate, oh, this only applies to common employee, issues, while the arbitration agreement says, well, no, it applies to anything even outside the scope of employment. As the 8th District Court of Appeals pointed out, somebody may be willing to agree to arbitrate something regarding his duties as an employee, but certainly he's not going to agree to arbitrate any claim outside the scope of his employment or something that happened after he leaves the employment. Also, when you look at the uneven bargaining positions of these people, on the one hand you have a minimum wage, low-skilled, basically high school graduate making minimum wage versus a company like Burger King. Here's a man who was trying to support his family of 5. Is he supposed to give up that job and look for a job someplace else rather than appearing at work and then they claim that he agreed to it?
Why would that be unreasonable?
Why would it be unreasonable? Well, because when you look at the facts of the case, it took him 14 months to find another job. To expect him to give up a sure thing, he had a job, to go out and hopefully when the market get a new job, that's unreasonable. Secondly, if the court realizes it...
I don't mean to interrupt you, but would there be any reason why he couldn't look for another job while he was still at this job, so there would be a 14-month gap in time where there was nothing? I mean, he could have looked for a different job, right, while he was still at Burger King.
But the problem, Your Honor, is that by appearing at work on August 1st, he's agreeing to this agreement regardless of what happens to him after that.
Well, he didn't find out that on July 31st. He knew that well ahead of time, that as of August 1st, this was going to be in effect.
Well, your question was, though, why would it be unreasonable? It would be unreasonable because by simply appearing at work on August 1st, he's agreeing to this agreement. I mean, secondly, the other thing that the court has to consider here is that most of these other type of jobs, not only at Burger King, all of these fast food places, a lot of them have arbitration agreements. So let's say he decides, I'm not going to go back to work, I'm going to go for another job. So he goes out and they ask him, well, why did you leave Burger King? And he says, well, I didn't want to sign an arbitration agreement. They'd say, well, see ya. We have an arbitration. We have the same type of arbitration agreement. You want to sign it, we're not hiring you. So it's all of those things. It's not one thing, but all of those things which would show procedural unconscionability. Substantive unconscionability, again, the unlimited scope applying these agreements to even Erick's family, claims of Erick's family. The one-sidedness of the agreement. For instance, now Burger King in its briefs argued that, well, all the claims that could arise out of the employment relationship are covered by this agreement, but in fact they're not all covered. A Burger King can go in and seek injunctive relief in a court if in fact they believe that there's some reason for that, confidentiality or whatever. And the point is that this is the kind of agreement that basically favors the kind of claims that the employer would make versus the kind of claims that an employee would make. It would be very rare for an employee like Erick Jones, a minimum wage employee, to go into court and want to seek injunctive relief. Same with a class action. If the court is aware, this agreement also says that you can't bring class actions. It's only an individual claim. Well, the only people that would bring or try to bring class actions in these employment situations is an employee. You're never going to have Burger King seeking a class action against a single employee. I mean, it's totally and unfairly one-sided in this case. Secondly, as I've explained, it's ambiguous and misleading. On the one hand, it says the posters and the memos say, well, this is just assures you this is common employment matters that it applies to. although the agreement itself says it includes even claims outside the scope of the agreement and post-termination claims. As I have argued before, the tort claims, Erick's tort claims, are not within the scope of the agreement, obviously because they occurred at some point after he was terminated.
But do they arise out of the employment? It says, I believe the clause used that term, didn't it? Arise out of or related to employment. Do you think those claims either arose out of employment or are related to the employment?
No, I think that they're unrelated, they're independent. That is, anybody on the street would, if they were defamed or had invasion of privacy or were wrong, they would have a claim against Burger King. It's just fortuitous, as I said, the only employment relationship here is the fact that it was an employee who was the tortfeasor. But for instance, there is a section under the Ohio Revised Code where a patron, anybody who is a patron of one of these restaurants, if there's discrimination or if there's some kind of claims, they can bring those. So these kind of claims really are independent of the employment relationship.
You have about 4 minutes.
Okay. The only other thing I want to point out is I think this contract also is illusory and lacking in consideration, because if you note, if you read the employee handbook, it's very clear and points out that any of Burger King's policies, including the arbitration agreement, is subject to unilateral modification or change by Burger King. That power basically renders the contract illusory, and I have cited cases to that effect in many jurisdictions. And obviously, while they may argue that continued employment is consideration for the agreement, obviously if there is no more employment, that is, he's no longer an employee, continued employment can't be a consideration for anything. So the agreement would be unenforceable under Ohio law simply because it's illusory and lacks that consideration as well. So I don't have anything else unless the court has any other questions for me. As I said, it's been briefed a couple times. I'm sure the court is familiar with the issues, and I'll reserve the rest of my argument, if any, for rebuttal. Thank you.
Good morning, may it please the court. As Mr. Kerper noted, we are before the court today for a third time, but it's based on a very limited directive. And that directive to the trial court was enter an order sufficient to permit appellate review. And in response, that's what the trial court did. In affirming its order compelling this matter to arbitration, it entered 39 findings of fact and conclusions of law, which are entitled to deference here. Mr. Jones, though, doesn't take issue with any of those findings of the trial court and instead makes the same non-factual arguments that he's advanced in each of his prior appeals. The trial court, though, in addition to failing to attack any previous opinions, found that Jones failed to do a number of things. The trial court found that Jones failed to provide an analysis regarding the JAMS process or otherwise make any effort to meet his burden on substantive unconscionability. With respect to procedural unconscionability, the trial court found that Jones failed to provide evidence that he was forced to sign the agreement because he could not obtain other employment and failed to show that the process was unfair. The trial court also found that Jones failed to introduce any evidence suggesting that his claims do not fall squarely within the four corners of the arbitration agreement. Finally, the trial court found that Jones presented no evidence suggesting that Congress intended to preclude a waiver of a judicial claim, or a judicial forum, for his claim that Carrols allegedly failed to maintain accurate pay records. Now, before I get into the other factual findings and their relation to Mr. Jones' arguments, I'd like to lead with the Arnold case, as Mr. Kerper did. The ruling, of course, has no binding precedential value here, and it shouldn't even be considered persuasive authority by this court. In Arnold, in addition to asserting what would be considered standard employment claims, harassment, retaliation, discrimination, the plaintiff claimed that she was sexually assaulted by her manager. And the 8th District referred to this as an outrageous tort. And the 8th District's opinion centered around this outrageous tort. In fact, according to the Arnold court, whether right or wrong, the type of claim at issue most certainly matters. The Arnold court stated that it did not seek to exclude all intentional torts from arbitration, but rather only those, quote, outrageous torts, end quote, that are legally distinct from the contractual relationship. There's no outrageous tort at issue here. More importantly, though, no evidentiary hearing was held in Arnold. There were no facts adduced in the trial court for the appellate court to rely upon. Instead, the court relied upon unproven allegations of the complaint and inferences based on research that the court conducted on its own. This is exactly the opposite of what this court has done here, where it has twice refused to substitute allegations of the complaint and supposition for fact, and has instead remanded this matter in order to discover more facts from the trial court. The Arnold opinion was also a limited decision. The 8th District held that the agreement was only, quote, unconscionable as applied to this case, unquote, tying its holding again to the alleged sexual assault. The court did not find that the agreement would be unconscionable in every case. Now, the Arnold court cites to Fazio v. Lehman Brothers, which was a 6th Circuit opinion, for the proposition that, quote, a proper method of analysis here is to ask if an action could be maintained without reference to the contract or relationship at issue. If it could, it is likely outside the scope of the arbitration agreement, end quote. Every case cited thereafter by the Arnold court involved a sexual assault. Here, Jones doesn't plead a sexual assault, nor is it the case that any of his claims could be maintained without reference to his employment relationship with Carrols. While Mr. Kerper has argued that there were claims that arose post-termination, they were still arose out of his employment relationship and within the context of it. One such claim that Mr. Jones alleges has to do with whether Carrols maintained accurate pay records. I think it's hard to argue that that claim had nothing to do with Mr. Jones' employment. He also alleges a defamation claim. Here again, it involves one of his former co-workers and arose out of his employment. Moreover, if it is the case that this court were to find that some claims arose out of his employment and others did not, there is nothing that precludes Mr. Jones from maintaining an action in court and an action in arbitration. That is simply the law. Now, Carrols strenuously disagrees with the Arnold decision, especially to the extent that it flies in the face of the statute requiring an evidentiary hearing in connection with the motion to compel arbitration, and to the extent that it's at odds with Ohio Supreme Court precedent.
But Arnold, they didn't differentiate, though. I mean, they said that it was unconscionable. I know in the conclusion they said it was unconscionable in this particular case. But all throughout the opinion, they talked about unconscionability procedurally and substantively. And I think even in the dissent, one of the arguments was that at least some of the stuff should be arbitrable, just like you were talking about, and some of it was not arbitrable. But they said it was nothing was arbitrable.
That is correct. They ultimately decided that everything was arbitrable, or not arbitrable.
Right.
Here again, our issue with that is there was no evidentiary record whatsoever. The trial court opinion in that case ordering or denying the motion to compel arbitration was one sentence. There was absolutely nothing for the appellate court to rely on. And there were certain arguments contained within the appellate court's opinion that neither Carrols had argued and Arnold had not argued either. The court had gone out on its own in order to find certain instances to presumably support its opinion. That, here again, from Carrols' perspective, were not factually correct. I believe in our appellate brief here, we reference the class action that the court found, but what the court neglected to mention in the opinion is that in the class action, the pattern and practice claim had been dismissed by the trial court, and only 89 of 511 claims remained at the time that the case was ultimately settled. But neither party was allowed to weigh in on that because the appellate court did that research on its own and did not rely upon an underlying factual record in reaching its decision. So I agree with you, yes, that is what they found. I completely disagree with the process by which the appellate court reached that decision, and I think that had it actually had facts in front of it, that the decision would have been different, or certainly should have been different, even if the court wanted to carve out the alleged sexual assault.
It seems to me that the court really was just saying there's at least 2 out of the 3 judges. It really shocks the conscience, basically. We dealt with unconscionability, that there's real no meaningful choice, that it's almost one-sided, those type of things that the courts look at. I mean, I'm not sure the evidentiary record changes those factors.
Well, I think that the evidentiary record here does change those factors. There was testimony provided by Carrols that had an individual wanted to take an agreement to a lawyer to consult with him or her, that they would have been free to do so, that they could have taken time. Here the evidence also supports that in Mr. Jones' case, the memo with the agreement attached was presented to him weeks before the agreement went into effect. And so had he opted not to agree with it, he had the ability to do so. The agreement is also not one-sided. It provides that either party can initiate claims, and Carrols is also bound to the agreement. So I think that a factual record does make a difference, and that those are facts that the Arnold court didn't have before it, and instead they relied on unproven allegations or inserted supposition where there simply weren't facts to support the decision. In dealing with some of other arguments raised by Mr. Kerper, the scope of the agreement is not unlimited. The claims, as was pointed out earlier, must arise out of or relate to the employee's employment. And Carrols has never argued that the agreement applies to claims outside the scope of employment. If you look at the wording of the agreement, it still provides that even those claims must still arise out of or relate to the employment. And to read the agreement in any other way, I think, is to read it incorrectly. And it's written in that manner simply so an individual doesn't try to plead around the agreement. And of course, Carrols does not stand here and say that it has any contractual relationship with Mr. Jones' family such that Mr. Jones' family would be bound to the arbitration agreement. We've also made that point clear in our briefs. The only individual who is contractually bound to the arbitration agreement is Mr. Jones himself. The trial court also found in its...
The only problem with that, wouldn't there be all the family members would pretty much have to read at the point?
If it arose out of, I believe that the way that the agreement is written is that if a family member is going to attempt to claim emotional distress, and that emotional distress arose out of Mr. Jones' employment, that it would be covered, but we're certainly not suggesting, as Mr. Jones argued, that any and every claim that would be asserted by a family member would be covered by the arbitration agreement.
But many of them would be.
Only to the extent that they would relate back to the employment. It all comes back to the rising out of or relating to the employment.
But when you're talking about like civil rights litigation and so forth, and things that may be racial, sexual in nature, ethnic, whatever it may be, there sometimes can be derivative claims in regard to family members for, just what the suffering that the individual has gone through, in their employment, and how that's impacted their lives as well. And those would be non-compensable, basically.
They wouldn't be non-compensable, they would just be subject to arbitration. I think there's a difference. If they go to arbitration and you approve the claim, that the agreement does not preclude those claims from being brought. In fact, the JAMS rules specifically preserve any and all claims of the individuals bound by the agreement. So it doesn't limit the ability to pursue a claim in any way, shape, or form. It just requires that they be pursued in the arbitral forum rather
So
than
a
court.
family member would have to bring something in arbitration?
Phrased in that way, I would say no. That's far too broad and far too general and not what the agreement provides.
Well, in my scenario, in my hypothetical, and in this case, obviously you have some civil rights things, but let's just say a family member had a claim in regard to that what you're calling arose out of the employment of the employee of Carrols. So how would they be able to bring a claim?
In an instance where, say, Mr. Jones' wife is claiming emotional distress based on his alleged racial discrimination suffered in this case, I think that would be a damages claim that could be brought in the arbitration, yes.
But who would bring it? I'm not trying to put you on the spot. I'm trying to just figure this all out,
Right, well,
These are the things that go through my mind as I'm reading all this stuff. I'm like, how does this all work? That's okay.
you're right, because she would not have standing under the agreement because it doesn't, but even if she were to try to pursue that in court, she would still have to establish standing to bring that.
Right, but she would if he were filing in court. She would have standing as his spouse. So, but anyway, I
think the argument,
I'm concerned about.
I think that the argument would be that based on the way that the agreement is written, because it's intended to apply to the family, that would probably be enough for standing. I recognize that there is not contractual privity with the family because they're not a party to the agreement. And here again, it would fall back on the arising from or related to Mr. Jones' employment. And I think that would be enough for the family member to have standing in the arbitration to seek those damages.
You have 10 seconds left.
Then I'll wrap it up and thank the court for its time.
Thank you.
Attorney Burke, you have about 3.5 minutes, sir.
Yes, Your Honor, please, the court, Judge Carr, you hit it exactly. First of all, this related to employment and that's not what the agreement says. The agreement says that it basically applies to the claims of the family members. And the problem with that is the family members aren't parties to the arbitration agreement. And think about that. This is Erick Jones. Now, is he supposed to figure all that out when he's deciding that he's going to enter into this agreement or he's going to return to work? All these arguments they're making about related to employment and outside the scope of the agreement, those are lawyer words. Those are lawyer arguments. Let's say you had Erick Jones. He's not represented by a lawyer. He's supposed to have a meeting of the minds with Burger King that he's giving up all these things. Come on. This is no lawyer will allow a client to sign an agreement like this. This is an unfair and overarching, unlimited agreement. The claiming that now even torts that occurred after he was not employed there anymore are covered. This court needs, well, I'm sure they have. If you look at the Arnold agreement, the appellees here talk about that there was no discussion of the JAMS process. Well, if you read the Arnold decision, also in this case, Carrols did provide the JAMS rules and the process to the trial court. In Arnold, basically, the Court of Appeals used that process to try to determine, how did you file a claim, what was the cost of the claim, and basically, 3 of those judges, learned judges, couldn't figure out what you had to do, and yet you're expecting Erick Jones to be able to do that? It's just The way that this agreement was applied to Erick Jones in this case is unfair, it's unconscionable, and this court needs, you know, as I put in my brief, when we're talking about arbitration, if you're talking about people that are sophisticated business people, you're talking about people that are highly educated or that have a lawyer, then I think arbitration, you know, if it's negotiated, that's a fair matter. But when you come to people that are basically unskilled in legal analysis, are basically low-skilled, maybe have a high school education, what this court needs to look at is fairness. And if the court does that, then I think what this court needs to do is to reverse the trial court in this case, send this case back and allow Mr. Jones to exercise his right to a jury trial and to have his claims decided by a jury.
Thank you both for the presentations today. The court will take the matter under advisement, issue a written decision which will note to both sides of the